20 words per minute. Get ready. Start. Leave granted. Stop. This appeal is directed against the final judgment and order dated 11/9/2017 passed by the High Court of Judicature at Patna in criminal miscellaneous application number 27078 of 2013, whereby the High Court allowed the criminal miscellaneous application filed by respondent numbers 2 and 3 herein and quashed the complaint filed by the appellant herein stop para. A few facts need mention herein below for the disposal of this appeal, comma, which involves a short point stop. Para by impugned order, comma, the High Court quashed the order dated 13 to 2013 passed by the Judicial Magistrate First Class, comma, Saran at Chhapra in complaint case number 21 oblique 2012, whereby the Judicial Magistrate took cognizance of the complaint filed by the appellant herein against respondent numbers 2 and 3 for commission of the offences punishable under section 323, 379 read with section 34 of the Indian Penal Code, 1860, by holding that a prima facie case was made out against respondent numbers 2 and 3 on the basis of allegations made in the complaint stop para. So, the short question which arises for consideration in this appeal filed by the complainant is whether the judicial magistrate was right in holding that a prima facie case is made out against respondent numbers 2 and 3 for commission of the offences punishable under sections 323, 379 read with section 34 IPC, so as to call upon them to face the trial on merits, or whether the High Court was right in holding that no prima facie case has been made out against respondent numbers 2 and 3 stop para. Heard Mr. Binay Kumar Das, learned counsel for the appellant, Mr. Prabhat Ranjan Raj, learned counsel for respondent numbers 2 and 3, and Mr. Devasis Bharukha, learned counsel for respondent number 1 state stop para. Having heard the learned counsel for the parties and on perusal of the record of the case, we are constrained to allow the appeal, set aside the impugned order and restore the order of the judicial magistrate dated 13 to 2013 stop para. The High Court examined the case in para 6, which reads as under stop para. On perusal of the impugned order, we find that it suffers from two errors. Stop para. First error is that the High Court did not examine the case with a view to find out as to whether the allegations made in the complaint prima facie make out the offences falling under sections 323, 379 read with section 34 IPC or not. Stop para. Instead, the High Court in para 6 gave importance to the fact that since there was a dispute pending between the parties in the civil court in relation to a shop as being landlord and tenant, it is essentially a civil dispute between the parties. Stop para. It is on this ground, the High Court proceeded to quash the complaint. Stop. This approach of the High Court, in our view, is faulty. Stop para. Though the High Court referred to the law laid down by this court in the case of State of Haryana and others versus C.H. Bhajan Lal and others within bracket AIR 1992 SC 604 bracket close, but failed to apply the principle laid down therein to the facts of this case. Stop para. The High Court failed to see that mere pendency of a civil suit is not an answer to the question as to whether a case under sections 323, 379 read with section 34 IPC is made out against respondent numbers 2 and 3 or not. Stop para. The High Court should have seen that when a specific grievance of the appellant in his complaint was that respondent numbers 2 and 3 have committed the offences punishable under sections 323, 379 read with section 34 IPC, then the question to be examined is as to whether there are allegations of commission of these two offenses in the complaint or not. Stop. In other words, in order to see whether any prima facie case against the accused for taking its cognizance is made out or not, the court is only required to see that allegations made in the complaint. Stop. In the absence of any finding recorded by the High Court on this material question, the impugned order is legally unsustainable. Stop para. The second error is that the High Court in para 6 held that there are contradictions in the statements of the witnesses on the point of occurrence. Stop para. In our view, the High Court had no jurisdiction to appreciate the evidence of the proceedings under Section 482 of the Code of Criminal Procedure, 1973, because whether there are contradictions or oblique and inconsistencies in the statements of the witnesses is essentially an issue relating to appreciation of evidence, and the same can be gone into by the judicial magistrate during trial when the entire evidence is adduced by the parties. Stop. The stage is at to come in this case. Stop para. It is due to these two errors, we are of the considered opinion that the reasoning and the conclusion arrived at by the High Court for quashing the complaint filed by the appellant against respondent numbers 2 and 3 is not legally sustainable, and hence it deserves to be set aside. Stop para. In view of the foregoing discussion, the appeal succeeds and is accordingly allowed. Stop. The impugned order is set aside, and the order of the judicial magistrate dated 13 to 2013 is restored because it records a finding that a prima facie case for taking cognizance of the complaint is made out. Stop para. The judicial magistrate is accordingly directed to proceed to conclude the trial on merits on the basis of evidence adduced by the parties in the trial, strictly in accordance with law, uninfluenced by any observations made by the High Court in the impugned order, and in this order made by this court. Stop.